It'd be a lot cheaper. All right, it's 8:30 and I'm going to call the Law and Government Liquor meeting to order. Can we have a roll call, please?
Sager.
Here.
Wagner.
Here.
Hendricks. Campbell.
Here.
Shorten.
Here.
Kunkel. Altoff.
Here.
Oh, Matt's on the computer. In here.
Do we need a motion?
Yeah, can we have a motion? Mr. Sager, seconded by Mr. Shorten, to allow Mr. Kunkel to participate electronically. All those in favor say aye.
Aye.
Aye. Welcome, Matt.
Thank you.
Is there any public comment? I don't think so. I kind of glanced when I walked by before.
There was none. Last call.
Are there any member comments this morning? Seeing none, we'll move on to new business. Jay, do you want to come up and take a seat, please? Ladies and gentlemen, this is Jay Herbig. He is applying for a liquor license. I think you saw that in your packet. Jay, you and I had a conversation previous to the meeting. Do you want to explain what the situation is and why you're seeking a license, why it's necessary?
Yeah, I work for Blackstone Golf Club and we currently have a liquor license. And over the winter, I'm setting up golf simulators in our dining room area. And basically, would like to serve, alcohol and then some food options. And I'm a seasonal business, basically from November 1st through March 31st. That's why I'm applying for the E-license. And the gist of it is my boss would just like me to be a completely separate entity, primarily, to liability issues. So I have to have all the proper insurances and keep everything separate from, the club business.
And it made sense from our perspective as well as to have Mr. Herbig go ahead and have his own license. Mr. Sager, you had a question?
Yeah, I just want to make sure. So it is an entirely separate business. I mean, you have a separate business license
Yes.
with the state.
Yep.
Very good. Thank you.
Anyone else have any questions? Mr. Shorten, would you like to give the serious speech about the responsibility of owning your own liquor license?
Fun speech, but
You weren't going to give a fun speech. This is the serious speech.
are we going to vote first or?
No, I think you're going to give the speech first, and then we'll vote.
All right, so we're going to have a vote in just a minute, and whether or not we're going to grant you the license, assuming that we grant you the license, which I feel like we're going to. Obviously, having that license and the ability to serve alcohol comes with great responsibility. I think you understand that, and we appreciate the fact that you're going to follow the rules, and it's a what's the right word?
It's a privilege.
Privilege that you get that. Good luck to you.
Thank you.
We just take these things very seriously,
Yes.
so we had to give you the Dutch uncle
Yes.
speech. That's just the way it goes.
Yeah.
Can I have a motion to approve the liquor license for Mr. Herbig? Ms. Campbell, seconded by Mr. Shorten. It is a liquor license, so can we have a roll call, please?
Shorten.
Yes.
Sager.
Yes.
Wagner. Yes. Kunkel.
Yes.
Campbell. Yes. Altoff.
Yes.
Thank you very much.
Thank
We
you.
wish you good luck. Here's your liquor license. Do you want to hand it to
Oh,
us?
yeah.
How you gave the speech?
And that's a lot of fun. I didn't realize we're at Chalet Hills.
Yeah.
It's a good time.
Thank you.
And we wish you well. Moving on, legislative update. Alicia, can I ask you to come forward and kind of give us an update on what's going on with all of our efforts?
Good morning, everyone. Or members of the public at home. My name is Alicia Schuler, Director of Public Affairs here at McHenry County. And legislative update. So first off, veto session is coming up for us, allegedly. It is scheduled for November 12th to November 14th, and then for a second week in November, from November 19th to 21. However, the governor didn't do any vetoes this year. So it's a bit uncertain whether that second week of veto will actually exist. There are some other scheduled events within Springfield right now for legislators, so they may keep that week there, but there hasn't been much noise about what exactly, if anything, would be discussed during that first week. So again, we're keeping an eye on it, and more to come. As for different legislative initiatives that are going forward in regards to transit, Chairman Bueller did speak before the House Public Transit Working Group. He gave the county's position on that, and there were several articles that came out recently from the Northwest Herald and created Chicago, where the chairman, gave a op-ed along with the president of the McCog, Rick Mack. So I linked to both of those stories in the report that I gave, so feel free to read them. There was also a very interesting story on WTTW's Chicago Tonight, where Senator DeWitt appeared along with Senator Ron Billam, and he appeared along with the different transit heads to discuss the potential MMA legislation. And again, it stood out to me, especially with Senator DeWitt, because he made a comment about how the MMA as the RTA may one day be called. So again, maybe there's a potential for a name shift in there. I'm not sure, but again, it's an interesting interview. Feel free to check it out when you have a chance. And again, we'll be keeping close eye on legislation as it develops. With that being said, there's also a very strong labor coalition that seems to have formed surrounding the possible merger of these different boards and its impact on workers. Again, from the Senate transportation hearings, it appears so far that labor is against consolidation. However, that's something to be monitored, and if they are going to develop their own competing legislation against the MMA, they would have to file relatively quickly. So to get that going for the next session. So again, more to come on that. We'll definitely be keeping an eye on that legislation going forward. Other pieces of legislation to keep an eye on.
Can I stop you there? Brian, do you have anything to add on that topic specifically?
I do.
As our RTA representative?
You want me to do that now?
Yeah, I mean,
Could we do one thing? Could we say what MMA is for the?
Sure.
For our people viewing.
Metropolitan Mobility Authority. First off, I want to say sincere thanks to Chair Bueller and certainly to Rick Mack of COG and others who've really done a remarkable job. Lots and lots of hearings. I know that many individuals listened into these hearings over the time, and I think that's been very positive. I think there are some things which are coming out, but I truly believe that the chair's work, Rick Mack's work, has done a yeoman's job of really communicating, not just for McHenry County, but for the other collar counties, what the concerns and what the needs continue to be. I do think that the reality is consolidation is going to occur. I mean, I want to be just very blunt and say that it's going to occur. There is a lot of momentum behind bringing all of these transit services together under a single board. And there's an ultimate reason for that, for which I don't disagree. I don't think Kirk Dillard, who is the chair of the RTA, disagrees either. And that is that right now, the RTA really has very little authority, to be honest about it. We have oversight with regards to finances, but when it comes to dictating, if you will, or leveraging priorities or the manner in which that money is spent, it becomes very difficult because we don't have any leverage. We don't have any back push, if you will, on that. So I do think that Chair Dillard in particular believes that this is probably a much better situation, and I would say that that's shared by the members of the board. Now you might say, well, the board is in a tenuous situation anyway, the RTA board, and it is, but the whole idea, as forwarded by CMAP as well, was that we do look at oversight of the financing with a greater amount of authority by the RTA board so that we don't have to work through these other boards. So that's one thing. I do believe that there's acceptance of that. Not to diminish, though, the labor element, because that is a big push right now. Two primary labor units are really pushing this, and it's yet to be seen how that's going to affect the overall outcome. There are three things, though, that we are dedicated to really, really working hard on. And at the latest COG meeting, it was agreed that I was going to work with Chair and with Rick Mack and others to kind of forward a white paper, if you will, with just the basic points that we want to make sure we're getting out to all units of government relative to approach on this. Again, I will honestly say it's with acceptance of consolidation. But the three other points are, one, the representation. We want to make sure that representation is appropriate and is not overweighted by appointees from the governor, by Cook County, by City of Chicago, so that it just automatically put it on the scale and it's just so far gone, it puts us out of business, if you will, in terms of our participation as a Collier County. So representation is a major issue. The second major issue has to do with the majority vote. And as you are aware, as we've discussed before, the initial foray into this and that legislation stated that they would move to a simple majority of the board versus the supermajority as it exists right now. Supermajority right now is 12 out of the 17 appointed members, if you will, which is a positive thing for the Collier counties because we only have 5 votes. And so if the Chicagoland area needs to get 12, it's not always easy, especially because some of the Cook County representatives are suburban Cook County representatives, which is to our favor. So we want to make sure that it maintains a supermajority requirement to continue that balance or that stability. And the last thing is the money. And the money is the money is the money is money, right? That's what it always comes down to, is the money. And it's important to understand that we operate under what is considered to be a formula that has been accepted for quite some time, except when you have truly differential opportunities, such as the ARP. In that situation, the monies were distributed in a different fashion, with more money going to CTA than it did to Metra or to RTA under the normal formula. And the reason was the needs at that particular time. Now, not all of us voted for that, not all of us supported that, but a supermajority did rule on that. So it's important to understand that our normal formula is CTA receiving 58%, Metra receiving 34%, and PACE receiving 8%. So it's 58, 34, 8%. Now, what am I talking about? I'm really talking about the sales tax distribution for RTA and other state and federal funding that might come in on a normal type of basis. And I'm painting a huge broad brush umbrella here because the RTA and transit system funding mechanism is hugely complicated, very complicated. But at the same time, that's the basic formula that we operate. There is discussion that they want to change that formula so that the CTA gets a larger portion of that. And the reason is because the CTA has debt, huge debt. CTA currently has a $6.9 billion debt, $6.9 billion debt. That is because they have the opportunity to extend bonds. Metra has been very reticent to extend bonds or debt, and so they're in a very solid financial position. PACE is in a good, solid financial position, but the CTA is not. Let's not forget that this was the primary reason that this was being pushed by Tony Preckwinkle, the chair of Cook County, because they're wanting to distribute that debt out across the entirety of the system, not just by Cook County. $2 billion of that has to do with pension debt. So $2 billion of the $6.9 billion is pension debt. Now, I think we have to understand that there is going to be change. We want the change to be in the form of governance and authority with the RTA to get a better handle on this. But let's not pretend that there's not going to be some other challenges with this, because there certainly will. And this is not anticipated to come up in the veto session at all. It's planned for the spring session after all of these hearings that have been held. And so we're kind of waiting for the reports that come out prior to consideration from the hearings. And we don't know anything about schedule yet. But our hope, our desire as McHenry County residents, in my opinion, is that they're going to have to come together with a package of revenue sources. The CMAP reduced from 15 options that the RTA had put together to 7 options that they presented to the state. And of course, in my humble opinion, we need to look at all the options early on. We shouldn't just start whittling things down because they're uncomfortable. I think we have to look at all of them. Let there be no illusion that it won't include a metro sales, or excuse me, an RTA sales tax increase. It will. And I think we have to be aware of that. But other things that are on the table are many things such as highway mileage charge instead of just resting on the motor fuel tax, etc. It's important for you to know that Chicago transit system is the most underfunded transit system of any major metropolitan entity of the United States. We're the lowest. But we have some of the highest functional outputs of any of those systems. And so it's an astounding thing that we've been able to do what we've done, but we're in sore need of reconsideration that's coming. What comes with it in terms of the governance and the voting and the monetary distribution formula, we don't know. So that's what we're doing.
With your permission, I have two questions and a comment. Tell me, do we have an idea of what the overall ridership is on CTA, where it comes from geographically? And then with regard to the bonding authority, et cetera, who makes up the board of the CTA that makes those decisions and has actually, obviously underfunded their pensions and has gotten us into this debt crisis?
Okay, two things.
Yeah.
The major ridership of CTA is the suburban core, not the suburban core, but the urban Chicagoland area and some of that surrounding Cook area. If you look at the maps, I could bring that, but there's heat maps out there that have been shown that it is all within that region for CTA. No question about it, and it's heavy, heavy, heavy. And so that's one of the reasons that the justification was made why more art funds should go to the CTA rather outside of the normal funding formula. So that's that. The second thing is, and please, I shouldn't say this, but I'm going to, I'm not a huge fan of Dorval Carter, who is executive director of CTA. And I believe he's kind of led the board down a difficult path. And that membership, I think, is kind of just followed with a nose ring. I'm sorry.
And it's made up of all people from the Chicago. And Cook, the suburban area, and then how many members?
Let's see, I think they have, I'll have to go back and look, but I think they have 9 members.
9, I was gonna say 7, but it could be 9, I don't know.
I'd have to look that up, maybe.
Again, just to give you a full kind of scope of what we're talking about in the event that anybody asks you any questions. Mr. Shorten.
Can you expand upon, and I think I know how it's defined, but the highway mileage charge?
I knew that.
Go into that a little bit
Yeah.
in detail?
Yeah.
Well, that's been on the table for, what, 15 years now?
Right.
And it was talked about when you were down there, I know. And that would be monitoring highway usage versus putting so much dependence on the motor fuel tax because of the change in motor fuel tax associated with EVs and those types of things. And so that's part of it. Again, it's been considered for a long time. It's never really truly been addressed because there wasn't enough. Even though at that time, Leader Cullerton, President of the Senate, he was a big promoter of it. He wanted to see that done, but just didn't have the legs at that time.
Right, I was gonna say it was a huge conversation at that particular time. And even with the unions, we brought in the unions to talk about construction and lanes, et cetera. And basically there wasn't even support from that entity as well. So it just kind of died on the vine.
I do think there's going to be reinvigorated strength with that conversation as we continue to look forward. But I don't know that it has as much. There's a lot of opposition to it, a lot of opposition.
And the only other thing, are there any other questions? Ms. Wagner, I'm sorry.
So, I heard, and this may not be true, but do you think there is any way that if there is consolidation, that the debt does not go within the consolidation, but it stays within CTA, so the other counties don't have to take that on?
It's a good question, but I have no hope. I wish I had hope, but I don't really have hope.
And they're looking for basically a bailout. I mean, it's huge.
No question about it.
Mr. Short.
No, it's just another bite at the apple, and because I've kept my mouth quiet on this, and I appreciate the explanation, and I understand where it's gonna go, but I use Mr. Kern's word, bull. This is a Chicago problem, and you're right, maybe they're not funded. It's a Chicago problem,
One of the challenges, but
and we're bailing.
with all due respect, that's what we do in the state of Illinois.
I know,
So I'm not gonna say anything else about that, but, and maybe Peter can add to this conversation.
He is, he's wiggling back there.
The other thing, though, that I think we have to be aware of is that there is a huge amount of background politicking going on. Lake County has kind of, Sandy, who's the chair there,
Sandy Hart.
has kind of drunk the Kool-Aid, I guess, a little bit. And there's a part of me that wonders what kind of, and I shouldn't imply too much of this, but, you know, there's a lot of politics behind the scenes on this, so.
I imply it?
No.
No, don't. Mr. Austin.
Yeah. Couple things, that, you know, staff continues to have regular meetings with RTA county staff members, and we've been meeting about every other week. And I will say that this past Friday, 4 counties, Will, DuPage, Kane, Lake McHenry, I guess that's 5. No, not Lake, 4. We're able to kind of be, you know, stating that we maintain a position that we'd like to see a stronger RTA, but consolidation is not the preference. Lake is not there. You know, the Lake representatives are clear that they're not in a position that they can say Lake has a formal opinion. But you mentioned, you know, supermajority. That's probably the most important thing on the table, because whatever the structure looks like, it's the supermajority that has been viewed as the most important thing because of the CTA debt, really. I mean, that's the biggest reason for the supermajority. You can start to see how this can unfold when Dr. Sauter says, well, if the General Assembly changes the formula for distribution and CTA begins to get more than the 58% that we're getting now, then that supermajority vote becomes less important if the General Assembly has already taken, you know, the routing of the dollars in a different direction. We did have a conversation, myself and Scott Hennings and Chairman Bueller with the drafters of the MMA, representatives from the Metropolitan Plan Commission a week or so back. And we talked about the supermajority and maybe that we had some conversations with county staff about this. Maybe the supermajority is a tool only for certain types of votes, right? Because the MMA kind of envisions that they need to be more nimble, they need to be more innovative, and sometimes the supermajority kind of deters that innovation. So I said, well, by all means, let's have a simple majority for innovation, but for the big items, the capital plan, the annual budget, those sorts of things, that's where we still want to see the supermajority. So those are the kinds of discussions that are unfolding. I think you could see a vote that's different, you know, simple majority for some items, supermajority for other items. That supermajority might be a mild supermajority, maybe 11 out of 15, you know, 11 out of 16, something like that. But those are some of the things that are going on. But this all, you know, this, if the General Assembly changes the formula allocation, that kind of takes some of that angst out of the supermajority, because it'll be done.
May I ask,
May
may I ask a consideration? This conversation for the newly seated board sometime in December or January, so that we bring everybody up to speed, and by that time, I'm sure that there will be different iterations of what's going on. But I think this is important enough for everybody to have a much better handle on what's going on, if we could do that, please.
Sure.
And I don't care if it's through this committee and we invite people, or if it's at a committee of the whole, but I do think that the full board needs to have that conversation.
You know, just a reminder, at your November COW, we will have RTA, PACE, and Metra
Right.
to do their annual budget report, but I don't think anybody's really in a position to have any.
I don't want to ask them to do that. I just,
That's not what they're there for.
politically, yes, thank you. I'm sorry, any other questions on this item? I'm sorry, Alicia, back to your report, thanks.
Thank you. There may be a lame duck session later on this year. One of the issues that seems to be bubbling up is Tier 2 pension reform. There's been some concern in the General Assembly that Tier 2 pensions may be subject to future litigation. But again, there's been several bills that have bubbled up over the time that may be able to be vehicles to provide solutions to that. Again, I'm in close contact with Joe McCoy of ISACO, and I'm also monitoring different vehicles that he thinks may be a possible way forward for that legislation if it happens to go in lame duck. So again, keeping my eyes open and monitoring and staying in touch with ISACO on that.
And then do you want to give an update where we are with some other issues? With reaching out to the department heads as well as the meeting on Friday?
Yes, absolutely. At Gerald, some instruction, I did send out an email to the different elected officials and department heads saying if you've got some pieces of legislation that are being put forward by your professional bodies or your professional associations, please let us know. We're interested in at least seeing some of these potential legislation items and putting them before this committee to vet further and see if there's a possible that they have to have some correlation to county business. So again, we're seeing what comes out of that and what people put forward. Chair Altoff and I have also reached out to Dr. Koenig and Jake Victor of the Housing Opportunities Development Corporation and North Point Development, the folks who work with us with the Advanced McHenry County funding to help with the Taylor Place apartments. We are looking at ways to learn more about IDA regulations and how the workforce housing process works, because there's a lot of complication to it. And if there's a way that we can streamline, we would like to be able to help with that from a legislative perspective so that there can be fewer barriers to workforce housing developments in the county. So again, but this is a learning meeting only for this time, just to understand the issue better.
It was one of the issues that came out of that working group is that the process at the state and the federal level are so onerous that from beginning to end, some of those developments were taking 5 years, which really screws up your financial formula. So one of the outreaches will be this, to talk and see whether or not we can actually figure out if this can be streamlined at both of those levels and make a recommendation and then do whatever. It'll be a long process. It won't happen overnight, but that was one of them.
Just so you know, just to give you an idea of how complicated this is, Scott Hartman and I came across an email from IDA offering cohorts of individuals who are developers to come in and take weeks worth of classes to understand how to become certified to actually, put on a, development through IDA. So again, there's a lot of regulation to understand, and perhaps if there's some way we can help, we can make this a bit easier here in McHenry County.
And then we also are working with Representative Ness on the social worker program for the Sheriff's Department. Obviously, if veto session is truncated, which I'm almost confident it will happen, we won't have enough time to do anything. So we're actually had a conversation with Representative, I do this all the time, Edie Allen, about, she's carrying the bill in the Senate, and obviously it passed the House, so the issue is in the Senate. So we're having some further conversations to see what we can do to promote that entire issue and move that forward. Yes, sir.
Can I discuss that 3646 we were talking about earlier this week?
Yes, absolutely. Let me finish and we can do that too. Anything else that you have for the good of the order that we're doing? Mr. Shorten, please.
So I got a frantic call from a constituent last week, happens to be my daughter. She's worked as a manager at the Cary Park District School, Summers Bay, since she was 15. And she helps run the entire operations during the summer, and they're in the midst of their planning phase, figuring out how to hire and make sure that they're fully staffed, which is challenging to begin with, to get A, people to apply, B, to get the younger set that will be hired and then show up, And there was a law that was passed earlier this year, SB 3646, which had to do with child labor laws. And what the key component in that law that is really giving Summers Bay some heartache and is going to affect a lot of local small businesses is it requires if you have anyone under the age of 16 working for your business or your organization, you have to have a manager on duty that's 21 years of age and older. Now, if you can imagine, like most district pools going back 100 years or however long they've been around, the managers are not over 21. You have head managers that are over 21, but they can't be there 24/7. And the same thing applies to small businesses on the local level. So I reached out to Pam and made some calls on that. But
We're going to get a better interpretation of exactly what it is and whether it also applies to family members or whether family members are exempt. So we'll go ahead and do that. I'm opining that it came directly out of the entire scandal that occurred in Chicago with the lifeguards and the whole problem that they had with the underaged. And then obviously their managers were young people too. And so that whole situation occurred. I'm assuming it came from that, but we'll do a little bit more investigation. Anything else for the legislative agenda? I do believe what we'll try and do again is in January, we'll invite our legislators to come forward. Good time for, again, new seated county board members to meet their legislators and be after their elections as well. And we'll see what they have on tap for their legislative agenda moving forward in 2025. Thank you very much. Routine consent agenda. Does anyone have anything that they need pulled from the routine consent agenda? We do have people in the audience who are here to answer any questions if you may have any. Ms. Campbell?
I would just, it's not a big deal in terms of yes or no, but on 7.1.
All right, so we'll pull 7.1. Do I have a motion to approve the routine consent agenda, 7.2? Ms. Wagner, seconded by Mr. Shorten. Can I have a roll call vote, please?
Sager,
Yes.
Hendricks,
Yes.
Wagner,
Yes.
Campbell,
Yes.
Shorten,
Yes.
Kunkel,
Yes.
Altough.
Yes. 7.1, our coroner's here, Carolyn.
Just, I'm just a little bit wondering, there aren't any dollars in here and there's no dollars in the extra information that's attached to it. And we usually at least try to have an idea of what we're looking at and what that's going to be over the course of the contract. And I think one time I sent it back to ROE because they didn't have dollars. So I kind of feel like fair is fair, that I really would appreciate some consistency and maybe I think going forward, maybe we can talk to admin services about, is there kind of a formula we would like to have for across resolutions about what should or should not be in, so people aren't guessing, right?
I understand that. I actually ran it through Carrie, and she's the one that put that on the resolution per se. Is that what you're looking at?
I think we just want an amount.
Well, the amount is in the contract. Are you talking like
Well, whatever, yeah, no.
each person? Because, well, the other problem you have is that obviously these are based upon autopsies per year and things of that nature. So what that may or may not be, I mean, if you want a range, possibly.
Yeah,
or,
I think, yes, I think
or
that's
something in that
exactly
nature.
what we're asking. Again, more information, it is on a per autopsy situation. Typically on an average, we have X amount may go above or beyond, so here's the range.
Yeah,
I think they're
and
just
we-
asking for more of that
We talked
kind
about
of.
this in our budget as far as what was going to happen for this,
Fiscal
going
year.
forward and things of that nature, budgeted things and stuff like that. And like I said, I ran the resolution because I didn't know what was like.
Understood,
Yeah,
no,
I wasn't sure.
no criticism here,
No,
just that
I'm
we're
just
not.
trying
not
to,
at
I
all.
didn't know.
There's
I didn't know what to put.
There's an unknown, right? How many autopsies actually need. Of course, we can look back the last 3 years of Dr. Rain's term, of what the average number of autopsies have been, and we can back into a number. However, he and his team, I think, are acting a little bit more efficiently with calling for autopsies now, right?
Correct.
You're
Yes.
more experienced, more confident, so while we know he was getting a bargain at these autopsies for a few years, now we're kind of back to market rate, but.
Correct, and the thing of it is that our autopsies have actually gone down quite a bit over time.
The price is
The
going
past
up,
3
the
years.
numbers going up.
So, but like I said, I mean, I can kind of probably gauge it, and if I can send an email out if you want me to do that,
I do.
and I can kind of, it's not a guarantee, but it's kind of.
Understood. I think all the
yeah,
information,
somewhere in
that's what I'm saying though.
so.
All that information
Sure.
would have been valuable for a decision-making here. It doesn't have to be a specific number, but that information of going down and going up and, will give us a better idea of what's going on. Ms. Wagner?
So are these contracts the
Mhm.
only thing that goes in this budget line? Are there more items that go in this budget line?
Say that.
So, okay, the budget the line that this is taking care of, the account,
Mhm.
are these contracts the only thing that are taken out of that account?
Or are they lumped in with other contractual
This
services?
specific line item,
Yes.
I think this is just autopsies. Specific.
Okay, so maybe it's even as easy as not to exceed the budgeted amount of blah.
There you go.
Yep, I agree.
And that way we have a number in there.
I don't know if you'd use exceed.
So
Because,
not to exceed.
well, even not to
Because
exceed.
if it comes back, then we have to approve a special line item change to
Well,
the budget.
I think not to exceed means that the issue is that by state statute, these have to be paid by the general fund, period. It's not a, either or it can be moved around or that type of
You
thing.
guys are both right, I mean,
Yeah.
we can work on the language still. There is an autopsy line, and it's got a finite number on it. It's in the 3,000 series, so other professional accounts you could move in if the autopsy line overran. It would not have to come back to the board if it stays in that series, but we can prepare an extra whereas to that point and add it on for Vista Finance.
Yeah.
That just gives us an idea what the number is.
Yeah,
It's easier that
yeah.
way.
I
No,
think what you're
understand.
hearing, and I've heard this in other committees, particularly administrative services, we just would like an idea of the cost. Is it in the budget? How much was it? How much do you anticipate? I mean, just from a fiscal responsibility, the more information we have, we feel better about giving you a yes. That's what I'm hearing.
Yeah.
Ms. Campbell?
Yeah, and I think just partly too, when this information is in the budget, I mean, in the contract, and I get that. But generally, people, I mean, it's also something if somebody from the public wants to look up, it's a little bit easier if they can go right to the resolution. They can look at the support, there's that informational page that attaches to it. A lot of times it's just repeating the resolution, just in paragraph form. But it has enough information that they don't have to, okay, now they're gonna go digging into the contract to find out what that
Right,
is.
and then the other thing is that I think in previous years and stuff like that, we weren't budgeting, obviously we don't budget for worst case scenario, things of that nature, obviously. But it was always going to be under budget every year, no matter what, that we were budgeting it for. And so I think the finance committee kind of wanted to change, that's how it got the ball rolling as far as changing how it was funded and things of that nature. The other part is that not all of the cases were done by a certain amount of time because, these do take 2 to 3 months and things like that. And then, we're always into the next fiscal year, that type of thing and stuff like that. So that was kind of the change partially with that, as far as how finance was wanting to do this. And, I asked them how they wanted to do it. How do you want to handle this and things of that nature as far as budgeting, things of that nature. So, but, I think we've, especially over the past couple years for sure, but, this past year we really tried to get things buttoned up as fast as much more faster, getting things as we've gone forward, understanding what autopsies we need to do and things of that nature. So, but I can get that to you. Are you guys looking for like a range or just?
information, and if
Okay.
it's a range that you can give and you feel comfortable, that's fine.
Yeah.
And I think the message is to everybody is that you'll hold Peter accountable and vice versa. We just need to know exactly what you just provided us, is that it is a bouncing number.
Sure.
And that over the years, we've had X amount and we haven't had to spend X amount of dollars. But this, the cost has increased, so per autopsy costs us more,
Correct.
but the number are going down,
Right,
which,
yeah.
so that's all we're looking for,
Yeah.
right?
It could be just saying, here's the cost that we're gonna be facing per autopsy. This is the number that, on what we've had in the past, right? All right, that's just very simple. We know in general, you've had this many autopsies, now the price is now this per autopsy, this is what we're anticipating.
Sure.
It doesn't matter what the total
I
is,
just-
it's just easier.
I just think, don't ever assume we know, because
No.
we don't know,
No.
right?
Right.
Okay.
That's fine.
Anything else, you're good? Okay, may I have a motion, Mr. Sager, seconded by Ms. Campbell, to approve 7.1 of the consent agenda? Again, roll call, please.
Shorten,
Yes.
Hendricks,
Yes.
Wagner,
Yes.
Campbell,
Yes.
Sager,
Yes.
Kunkel,
Yes.
Altough.
Yes.
Madam Chair, can we
Sure.
feel free to edit that background sheet there?
Yeah.
Put
Sure.
the information there.
Just a quick question. When
Can you
does,
even amend the motion to say that the resolution will be amended?
when does the finance meeting meet? Do you know?
Thanks. Yeah.
Okay. And
Brian's on it, Kelly's on it, Carolyn's on it.
Okay. So, but I'll make sure it's, I'll get it done in the next couple of days. and
That would
stuff
be
like that,
great.
And then I'll send it all to you guys and we'll
And have it ready for
have it
finance?
ready for
That'd be
finance,
great.
so.
Thank you.
Thank you.
So, okay.
Thank you very much.
Sure.
We have no presentations, we have no old business, and we move to the reports of the agenda. This is more of a discussion of what was discovered. So David, can I invite you up? Adam, probably you too, and I don't know if it's Kyle or Norm, but all of you are up here because it deals with emergency management, state's attorney's office, as well as planning and development, who basically deals with our liquor. We brought the guns out. So David, can I ask you to kind of give the background information, how kind of all of this came up? And then we can have kind of we're looking for direction on how maybe the county wants to handle this circumstance. So David, please.
So we recently changed, or you recently changed the UDO. It used to be if there was going to be an event in the county jurisdiction, non-incorporated area, of more than 2,500 people, that whoever was holding the event had to have an incident action plan, which promotes the safety of those attending and those around it and of the event, and it basically gives us an idea of what they plan to do to address security and safety. That was recently changed to 500. It turns out there's a lot of events occurring in the county that only have 499 people, but there are a number that have 500. And Brooke, who I recently hired and gave her this headache of approving these incident action plans, has been wrestling with something that they've been trying to do, or they have been doing, and that's BYOB.
And many of these events also hire law enforcement for access and exit, right? Ingress and egress.
So Adam can speak more to that, but the way
Yeah.
the ordinance reads is that they can hire sheriff's deputies, they're posted, or they provide a security agency that's agreeable to the sheriff's office. And the sheriff's office has certain requirements that be licensed and bonded and some other things, and that's the sheriff's purview, I don't know. My concern is in a BYOB, I'm approving a safety plan. I'm concerned for what my liability is, emergency management, or the county's liability is. We agreed to allow this to occur. And when we look at the advertisements for it, you know, it's, some of the advertisement, it's a drunken mess is what they're advertising for it. We can't legislate that part of it, but it's the BYOB, and there's no license.
Yeah, just bring chair up.
both Brooke and Sarah, who is an intern with us, have been or are bartenders, and they're familiar with the requirements that a bartender has or a business has. So my concern is BYOB events going under control. There was an event this weekend. There were fights that broke out that required the sheriff to respond. There was rescue calls. There was burglary to vehicle. There was, I can't say for sure, but boy, there was an awful lot of traffic occurrences
In that general
closing time.
region.
Around closing time.
And I think what also Brooke had brought up was the fact that there's nobody obviously carting. You bring your own, and nobody is managing who has access to the alcohol, who does not have access to the alcohol, right? So that was another aspect of the situation.
At the door if you're walking in, but naturally, I think if you're underage, you're not gonna walk in with alcohol with your card. But with over 500 people in a dark, large building, I just got off the phone with someone, a chief with the sheriff's office, and his statement was, they are handling incidents. They do respond to incidents at these events involving underage drinkers. It is a problem, and a lot of times these private security companies just use a stamp to indicate who's drinking and who's not drinking, or who's of age, who's underage. It's very easy to remove a stamp or
How do you know that,
lick a
Brooke?
stamp and transfer it to somebody else. You know, I think
We
It's a
made a
concern.
recommendation that they wristband everybody. One color for those who can drink and one color for those who can't. So it's easily identifiable, anybody working it. They rejected that on the last two permits. But it was our thought process to give them better tools to do it.
So we find ourselves in a situation of potential liability. So I did ask Kyle to come today to talk about maybe what other counties do, what you might recommend, what we can do, what we can't do. And then also Adam can weigh in on from any other aspect, because you have the overarching regulatory responsibility. Yes, Carolyn, what
Before I go
question?
to that point, just to clarify, because I didn't
Yeah,
quite
go
hear
ahead.
it, there were incidents that happened?
Multiple.
Were there any like on-site, like fighting kind of
Oh, yeah.
things? And then was there anything having to do with traffic accidents? And was,
Yeah, but I can't,
no, there was one that I just got off the phone.
but I can't say,
There's no
No,
proof that they
there
were
was-
associated.
oh, there was
There was
one?
one.
Okay.
Yes.
I'm sorry, I'm having a little trouble.
There was one that law enforcement has a report of involving someone who left one of these events and drove off the road.
Okay, thank you for clarifying. Thanks.
Kyle, floor is yours.
Thank you for having me today. So ultimately, one of the questions that was posed to me for discussion today was ultimately whether or not the county, through the authority that's promulgated to the county by the Liquor Control Act, could enact some sort of regulation as it relates to liquor licensure for BYOB. Ultimately, generally, it's a little bit more complicated than a yes or no, as is the typical lawyer answer. I know that, and I will wear that. But here's ultimately what I mean. So the county, and I'm going to compare this to the municipal code a little bit, because the county's code, the statutes, and I'm not talking about our ordinances, the county's code isn't as clear when it comes to regulation of specific areas that would fall under BYOB regulation. It isn't as clear as the municipal code, and I can give you those citations for that. But there's actually really no case law that I've found that specifically addresses the county's ability or authority or the extent of that to regulate BYOB unless it's under a general proposition of the general health, safety, and welfare authority that's promulgated to the counties through the Liquor Control Act. So I know that's kind of talking in circles a little bit, but I want to just make sure that we know what we're operating on.
And this is all on private property, right?
Yeah, so,
Right,
and
okay,
that's
just to clarify that too,
perfect
thank you.
segue into the issue. So ultimately, there's now, I guess, kind of some sub-issues, and I think really the crux of what is on everyone's, at the front of everyone's mind is what is ultimately the county's liability for this specific incident. And from my general understanding, and this is something that I can continue to research, but under the Tort Immunity Act, we're not liable as the government agency from providing licensure for somebody and then them engaging in illegal activity, which in this case would be providing alcohol to minors or fighting or whatever the case ultimately is. It's just a matter of ultimately to what extent we can regulate private events on private property, and that's making one big assumption if ultimately this truly is a private gathering on private property, right? So if ultimately there's alcohol that's being provided and whether that's being brought from the attendees and then there's essentially the equivalent of a corkage fee, maybe we're getting closer to where that's a situation that we might be able to look into further as whether or not that's a violation of our currently standing ordinances, whether or not they're providing that as a facade, right? Basically distributing alcohol without a license would be that equivalent. So I guess ultimately the answer would be, assuming that it's a private event on private property, the limits of our exposure actually don't come from what happens at that event. It's ultimately, in my opinion, the exposure of whether or not we're constitutionally infringing upon somebody's rights. So our exposure to the county would be from that particular event holder, challenging whether or not, from a substantive due process angle, whether or not we have overreaching regulation. Which there's plenty of case law about that, but again, that's its own kind of animal as to whether or not it would be subject to different levels of scrutiny, and that from anyone that has any exposure to constitutional law, that takes a full year out of law school, and it gets overly complicated as to what standard of review, whether it's rational basis, which I think is probably more squarely with what we're trying to do, because we're not targeting a specific, and I'm using, and when I say we're not targeting, I mean, I'm just thinking about a hypothetical kind of general regulation, right? It wouldn't be under the guise of targeting a specific kind of business or particular kind of expression, but then we maybe land more closer to intermediate scrutiny. I mean, I don't want to go further into the weeds than that necessarily, but it's a little bit more complicated than a yes or a no. Can we regulate a BYOB kind of situation? But to answer Ema's overarching concern, I believe that we do have tort immunity if it were, as far as a licensure action, because I think that's something that maybe we've discussed at the Liquor Commission as well.
We did.
Yeah.
But then why do we require a plan and, again, law enforcement to assist with entrance and exit?
Good question. So I'm, the authority that we're looking at to enact regulations or legislation, from my perspective, is the Liquor Control Act. The Liquor Control Act is the only method by which, or only vehicle by which we could pass legislation, and we actually have to stay consistent with that, with the state statutes. As far as zoning and as far as land use, the statute's a lot different.
So we're looking at
So we're looking at different methods by which to try to maybe get a handle on these kinds, because that's the ultimate goal, right? We want people to be safe if they're ultimately going to attend that. And I think that if you were to compare the statutes, which in all honesty, I haven't dove as far into the zoning statutes or the UDO as much as the Liquor Control Act and our ordinances. But from my brief review, I think there's a lot different of a lens that you can look through to enact legislation or ordinances as it relates to regulating that particular kind of event than under the Liquor Control Act. Does that make sense? So I guess the authority is a little bit different if you read the plain language of each of the sets of statutes.
Anybody have any questions or comments? And definitely Brooke, but from the committee members first, Mr. Sager.
Yeah, I just will plead my ignorance with regards to municipal versus county codes, but in the municipal codes, there really isn't a classification for BYOB. Municipalities can add a BYOB, but it's not really a classification under the state code for municipality. Is it a classification under the county codes?
So it's not a matter of classification. It's a matter of whether or not there's authority to create that classification, if that makes sense, right? So I'll read right from the municipal code. The corporate authorities of each municipality, this is under the municipal code, may license or regulate businesses operating as a public accommodation that permit consumption of alcohol on the business premises that are licensed under the Liquor Control Act of 1934. That language, from my review, does not appear in the county code. So that's what I'm saying. So I'm not saying that we can't or cannot. I'm just saying that to get to that premise, is a little bit different of a path under the county's code.
Right. I mean, in working with the state's Liquor Control Commission, they would tell you that, no, there's really not a classification there.
Right.
BYOB.
Right.
However, you have the authority under the municipal code to be able to go and establish regulations
Sure.
for public safety and well-being. And so you could do that if you wanted to. So that's what we've done, even
Right.
though we can't tie it to a classification code in the state statute.
Correct.
Okay.
I would say that is correct, and actually not to commandeer too much of your time, but the part of the issue for the lack of clarity is essentially we have, I believe Chicago actually advertises, not to throw them under the bus necessarily, but they actually advertise that they don't regulate BYOB, and that it is a different kind of aspect of business that that they've grown accustomed to, if that makes any sense. So I think that's why we're having such a hard time when we come down to classification versus ability to regulate versus what ultimately exposure is triggered for the county. So I apologize, I didn't mean to commandeer too much of your time, but
No,
it's a small slice of that bigger pie of what that constitutional analysis would be.
So I guess the weighty question in my mind is simply a balance. If we actually are offering BYOB through our opportunities of permitting, if you will, then we have this question about all these other, adjacent questions or concerns about the emergency plan and all those types of things. Is it better just not to worry about this because it is private property for almost the entirety of events, private property? Or are we better off because of our strong belief in public safety and welfare that we think that we have to be prepared, and so we'll go ahead and do that? I think that's the pivotal question, whether we just get rid of BYOB or whether we take a strong stand and frankly try to address these challenging questions. I mean, in my mind, I don't think we should ever have BYOB that's not associated with someone's particular liquor license. In other words, if you have a bar that is there at this event and it falls under a license classification that is provided and has been approved by the county, then they're the only ones that could run an event that would allow BYOB. But then you put them under notice that they're responsible for what happens there. That's, to me, that's what municipalities do frequently. And that's what I think we should be looking at if we're going to go in that direction.
That's the whole conversation we're going to have, because this has come up before. And Brooke, definitely, I know you have a question or a comment that you want to add.
So I just want to emphasize that while these events may be taking place on private property, a lot of them are open to the public.
That is the crux of this, and they advertise that, correct?
Yep.
That was this cross finger.
Promoters coming in,
There might be something in all of that too that we can look at, because there are flyers and there are posters, and they are actually inviting people to a private event of 499 people. They
It's
count
an
them as they
invitation to
want.
Woodstock,
Yeah, I know.
not Woodstock, Illinois, the Woodstock concerts I'm talking about. But are these events held under the auspices
I got you.
of a liquor license holder?
No,
See,
We don't have the liquor angle.
no, we don't have that.
But that doesn't matter. Well, but we could, there's no, right? We can't require them to have a liquor license, right? That's my understanding from this whole
That's
thing.
my understanding as well, correct, Kyle? We can't, the county is not given the authority to be able to create the BYOB classification.
Well, we have the BYOB classification in the county right now. We have that as relates to restaurants. We have that already.
Yeah, but,
Like a
So-
business.
right, but it's for,
Right,
but
so
it's,
that's associated with the business, but
Right.
now just, so I want to compare, I don't want to say carte blanche, yeah, go ahead and regulate, because this is a little bit sensitive and we'd have to be very, very careful on how that looks. But if this ultimately is open to the public, ultimately we're getting a little bit closer to maybe that is our ability to regulate something. But again, we have to be very careful with now all of a sudden we have this BYOB designation. Respectfully, this is a suggestion. I'm certainly not telling anyone to do anything.
This is
and we'll
open
have to-
conversation.
We'll have to look, to scrutinize how this ultimately looks. But if we have, even though it's taking place on private property, and because that's what liquor licenses, that's what we're doing anyway for bars, it's all private property, right? If we're looking at trying to regulate something, the more regulations that we have, ultimately, we're still going into this constitutional kind of analysis and paradigm, right? So just by virtue of the fact that it's BYOB, it's like that's something that we can look closer at if it's open to the public and it isn't like a private club kind of situation or not operating under the facade of being a private club, and really it's not because there's the free flow of the public. But again, that's a little bit, we're still in that operating in that gray area. So I'm not saying an absolute no, we can't. I mean, obviously if you're inviting family over and it turns out to be 100 people and everyone brings their own wine at Thanksgiving, that's a little bit different of a story, right? I think we can all agree that that would be substantial overreach, right? But we're now kind of operating in that gray area. So I think it's all factorial, and I wish I could give you a more straightforward analysis, but I think when it comes down to these particular kinds of possible exposures to the county, it's not, my concern as a state's attorney in defending the county in these lawsuits, or theoretically in these lawsuits, my concern isn't whether or not something happens at the event that could target the county, unless there's some willful and wanton kind of action, because we do have tort immunity for licensure, right? My concern is exposure to the county as it relates to constitutional triggers. So
And that's why we're having this conversation, because I couldn't answer completely David's question, and I certainly couldn't explain that. So again, Mr. Shorten and then Mr. Christensen.
So I just want to clarify, they're advertising public come out. Are they charging admission? Is there a business?
Sometimes
That's what I
yes,
want to say.
sometimes no.
Yep.
Each event is a little bit different. There's no standard.
Okay.
For what it's worth, some of the flyers do say we are not responsible for any accidents that occur. I mean, under social host law, they would be, right?
There's not, well, that's kind of combining a couple of different things that require a whole nother discussion. But there's a social host exception to liability when it comes, that's part of the whole reason for the Dram Shop Act, right? But one of the cases that I did find, not to go too far in a tangent, but one of the cases that I did find in my research was essentially the Supreme Court, I believe it was the Supreme Court, carving out a specific exception for BYOB at gentlemen's clubs, and then there being an incident thereafter. It's not as cut and dry as it kind of used to be, but so that would be private liability though. It doesn't have to do with, that would have to do with the people who are actually hosting the event, and whether or not there were any actions that were taken in addition to whether or not they're considered a social host and things like that. But
So-
you would be correct with bringing up that
So
exception.
the real question is, I don't want to make a decision and direct staff to do a huge amount of work if there's no interest from anybody on this committee to pursue that. So the question is the situation is out there, as David and Brooke kind of presented to you. There are some concerns from the state's attorney about how far we can reach to regulate. And then again, I'm assuming now I got it, zoning is different as to what you're gonna require for an event of that size. So the question is, do you want us to pursue this and come back with potential solutions, or is it something that we feel comfortable enough that we really don't have any jurisdiction over the alcohol portion of this? And maybe as we move forward, it should be more of a zoning, and we indicate that you can't, if you get this kind of plan, that you know, you can't pass out flyers or whatever it is. I don't know, but point being, what do you want to do? I think this is the exact kind of thing these committees exist for. So do you want to give some direction or just let it go? Mr. Sire.
It's not the first time that I've had to address these types of questions, or I think other people have had to address these types of questions. And I guess I would honestly say that I have always fallen on the side of protecting public health, safety, and welfare. I think that's a primary responsibility that government has. And so I think we need to clarify some of this and work a little bit harder on it. I'm not in a position just saying, okay, well, let's get rid of the BYOB and let's just kind of throw it all out and wash our hands of it and walk away. I don't think that's the right So I'm going to say that I think that we need to get a
Pursue.
better handle on this.
Ms. Campbell?
No, I agree. I really do. And then we just had this big accident over the weekend on Sunday where there was liquor in the car. They they passed in a no passing, and now the other person in the car coming over the hill, the adult was killed instantly. And the number of accidents that we're having on our rural roads, and many of them involving alcohol, I would think we'd be remiss in not trying to address this on some level. And I get the whole constitutional issue, and we can make sure that we're not crossing that line, but to not do anything at all, I think would be a terrible loss of an opportunity.
Consensus? So then I'm going to direct you guys to work together, right? Figure it out. Come back with some solutions, maybe what other counties have done or how they're addressing it. But I think this committee wants to investigate on how we can get some kind of handle over these situations.
And I appreciate that, and we will. And Adam and the State Attorney's Office have been fantastic. I have a lot of fear when we're approving something and it's not something I would let happen in my backyard, right? And I get, there's implications of the law or constitutionality or whatever, but we're looking at the advertisement and the target age is 18 to 24. It's not, and it's big time promoters coming to our county, getting locals to put it in the barn. And the last one, I'll put this up there, and it has nothing to do with legislation, but it's everything to do with your gut feel, is it's in a pole barn building with the horses stables looking onto the dance floor. My experience with horses is they get spooked by a spider, let alone loud music and people that are drunk and what have you. That just scared us, right? And that's why we brought it to you.
So what I'm saying though is listening to this is, and that's why I'm having all three of you. That's why I asked all three of you. Maybe it is more of a zoning as opposed to liquor. That you can't have these events unless these are your restrictions. I don't know. I'm not the smart one in the room. But between the three entities that we have in front of us, I think you guys can parcel something out that makes it easier for the county to feel that they have some kind of regulatory authority, as Mr. Sager said, for public health and safety, right? So that's what I'd ask you to do in a relatively decent period of time. Mr. Sager, did you have
I
something?
just wondering about one other angle, and I think it's important to address this. While people have a constitutional right to utilize their own property, that doesn't give them the constitutional right to endanger other people, right? And so I think that that's where we're crossing this line here. If it's an uncontrolled exposure to potential danger, then there is responsibility on behalf of that property.
And I think it does cross the line between, is this a private event, family
Right.
thing? I could never pull together 100 people, let alone 400 people for a private event. But so that does become a problem, but I think what we're hearing is that this is not just some private event. They've made this entirely public, and they're creating
But it's on private property, not
I understand
to
it, but-
parcel, okay.
But no,
just so-
I understand that then becomes a zoning thing.
Yes, exactly,
That's my point.
yeah.
So that's why I think it does take all three of you to figure that out, but I agree, and I appreciate you guys bringing this forward.
Mr. Kunkel, do you have anything?
I think,
I know, I got it.
okay.
I go to the committee first. I love you madly, all of you, but I go to the committee first. Matt, do you have anything? Weigh in, comment?
Oh, well, yes, just generally, stupid is as stupid does. But when it rolls out onto the public roadways, then we have to, of course, think about how that affects the county. Therefore, I think research into this is important.
Mr. Shorten and then Mr. Austin.
And I don't know if this is the same property, and whether it is or it's not relevant, but I had a constituent that reached out to me in the past couple of weeks because the property next to theirs was acquired. It's a residential, but the owners don't live there. They're using it as a party house. And
Happens all the time.
there's liquor involved, there's large numbers of people. The sheriff's been called out because they're in the back of the property shooting guns into the field behind them. And every time the owners of this property are confronted by either neighbors or even the sheriff, well, this is a private property, we're loaning it out to our church members to use whenever they want, which obviously sounds a little bit fishy. I don't know how Brian lives his life, but probably, I don't know. If I can use your property for my church parties, I'd
Angry.
Yeah.
I know, it's an issue. Mr. Austin?
One thing, and this is clearly after the fact, but now that we've had a violation, or we've had a permit and would we not have the right to send this property owner a letter that you lost your right to have a gathering in 2025 in that 1-year moratorium kind of language?
No.
There's
Yeah, I don't know
something
how
they
you
do now.
We've done that in some instances.
Yeah, we've done that in some instances, whether it's a breach of the conditions or some other, factor that led to them not obtaining the permit
I
properly.
don't know if that would be something that you guys could do or we could do with the other. That's just, I don't know, it's clearly after the fact and not as satisfying, but it is something to say you didn't live by the terms and you're not going to do this next year.
There's a mechanism. Yeah, to that point, there's a 1-year moratorium.
But I would think then that you better be darn clear from the very beginning, all of you who's ever involved, that you set the standards and the terms of those events.
Right.
Right?
Right.
And that there's some kind of document or witness or whatever it is that indicates that you've done all of that and you've laid those terms out pretty clearly before you can send a letter saying you violated it, right?
I'm just gonna add one
Yeah,
thing,
go
because
ahead.
we went through this
Yeah.
at PED.
Yeah.
The 1-year moratorium was just enough time for them to have that,
Party.
whatever it was,
Again.
again.
Yeah.
So, I mean, I think that's fine if it's a tool, but it's gotta have some teeth to it.
So I think you've got your direction. I would just ask that you keep me in the loop and let me know kind of how you move forward or if you need anything, and then just bring something back to the committee. Okay? No, thank you. I really
Thank you so
appreciate
much.
the fact you brought it to our attention. Seriously, thank you. We have no need for executive session, so. Oh, did we not do that? Can I have a motion to approve the minutes, Mr. Shorten, seconded by Ms. Campbell? All those in favor say aye.
Aye.
Aye. Thank you very much. I apologize. Thanks, Matt. Can I have a motion to adjourn? Mr. Kunkel, I heard you say that. Mr. Shorten seconds.